Welcome to Chemical Kafka. We have an interesting case to discuss with you today. The caption, as you can see here, DEA loses credibility. The underlying assumption here is that they had credibility to begin with. And we'll start off giving them the benefit of the doubt here, as the judge in this case seems to have done. Now, this case was originally reported, first time I became aware of it was when it was reported in a Google feed out of Minneapolis, Minnesota, out of a newspaper there called the Star Tribune on January 12th, 2017 by reporter Stefan Montemayor. And I looked into it a little bit and thought it was an interesting case, so I thought I would share it with you. And basically, a few details here, just to sort of get us started here. It is a case of credibility for the DEA and some data that they're supposed to turn over. It's a Freedom of Information request, and they do need to turn this data over, and for some reason they have a difficult time doing that, and they are taken to task for just that reason. So the initial request comes out November 20th, 2012, and continues. There's 2 or 3 requests to February 2013. Letters are sent to the DEA, and the information sought is from some wholesalers, some drug wholesalers, McKesson, Cardinal, Amerisource, also known as Bergen, and also from Walgreens, obviously a retail pharmacy outlet. And they're looking specifically for sales of oxycodone in Georgia. So it's not for the entire United States. It's a very small request, really. And it's a request for the years 2006 to date. So at that time, it was only about 6 years. Now, since that time, we're up to the year 2017 now. So we're up to basically 11 years now. But originally, it was only 6 years. And they didn't really get any satisfaction from the output from the DEA, so they filed a civil complaint. Complaint was filed in October 2013, so that's about 8 months after their last request. They filed the complaint against the Drug Enforcement Administration, and here's the case number. And the United States Department of Justice was also a party to this. The case was filed in the District of Minnesota, and basically the plaintiff here was seeking information in the public interest relating to the oxycodone epidemic excuse me, in the southeastern United States. The complaint really doesn't go into any more detail than that. We're not really sure if he was trying to decide if there was an epidemic, what the cause of the epidemic was, epidemiological patterns, what have you. That was the basis for seeking the information. And from that lawsuit that was filed, essentially the DEA had somewhat of a victory there. They turned over some information that was sought, but they really withheld a large amount of it, claiming it was confidential. They couldn't turn it over, and so the plaintiff, the individual that was trying to do a little bit of research, appealed. So they go up to the Court of Appeals for the 8th Circuit and try to get some relief there. The plaintiff, Maydell, says that the stuff really was not confidential, the stuff he was after, and he says that at the very least, the information that he was looking for, some of it could have been segregated. So he says, look, if some of the stuff that I was looking for was confidential, there's a good chance that at least some of it was not. So you can't withhold a whole bunch of it just because a small portion of it might have been confidential. So the question here, could the Excel spreadsheet, which this data could have been downloaded into, have portions removed and keep everybody happy? So in other words, they're going to withhold some information and disclose some, sort of a compromise type of situation. So they continue discussing the case in the Eighth Circuit opinion. The Eighth Circuit says, is sales data of oxycodone from 2007 really confidential and harmful in the year 2015? They kind of seem to think that it's not so harmful, and the DEA should turn that over. Also, significantly here, they say claims of harm are undermined by the DEA's public release of 4 charts showing total dosage units sold per month by Cardinal Health to 4 named buyers in Florida over 4 years. So this information that the DEA is saying, well, this is confidential, we can't release this type of information, it would be harmful. They did this exact thing that they're claiming they can't do in Florida for stores in Florida. And so why can't they do it in Georgia? And so the Eighth Circuit sends it back to the district court. And it's interesting when they do that, the Court of Appeals gives some direction to the trial court, and they specifically say the lower court had previously found that the plaintiff, Medell, was not entitled to attorney's fees. The Court of Appeals says, we're going to leave that question open. After what we have seen here, we're going to let the judge decide if this plaintiff should get attorney's fees. And we want the district court to specifically look into whether some parts of this data should be produced by the DEA, even if they can't produce all of it. Specifically, there's a question, if they don't want to get down into really, really small, specific parts of the data, perhaps parts of the data where they look at 100,000 or 200,000 units per year would really cause the same amount of competitive harm as disclosing all the data. So the large chunks of data might not be quite so harmful in disclosing the really small store-by-store type of data as the DEA is claiming. So that's the thing that the district court should be looking at when it gets back to them. So when it gets back to the district courts on remand, what do we see there? Well, what the DEA eventually tries to do is they try to end the case down there on what's called the summary judgment. Now, without getting overly technical, basically the summary judgment says, look, even if you look at everything in a light most favorable to the plaintiff, to Mr. Medell here, we should win this case. The facts and the law are such that we should just win. There's really no reason for this case to go on any further. And so that's what we're asking the judge to do. And the judge at the district court level, the trial court level, has a very different tone in this order than he did in the when the case was first presented to him. This is document 105, filed January 11th of 2017 this year. And I want to take a closer look at that because it really shows a little bit about the DEA and sort of what some of their tactics really amount to, and makes us sort of wonder what sort of agency we're dealing with when we have this kind of case. So we see here the document 105. It's filed January 11th, 2017. And we see Christopher Medell, the plaintiff, as well as the two defendants, the U.S. Department of Justice, DOJ, and the DEA, Drug Enforcement Administration. The DEA loses in this particular motion that's filed. This is the motion for summary judgment that we did just discuss very briefly. And we see here on page 1, there's just the caption if you want to look up the case and see some additional details there. And we can turn to page 8. This has some of the details that is really the focus of the discussion here. So it starts off by saying the court has given the defendants, the DEA, the benefit of the doubt throughout this litigation, and the defendants have time and again failed to establish that they deserve that benefit. You can just stop right there. The tone of this judge the second time around with the DEA is quite different, and he's going to tell you why. Whether by refusing to negotiate with Medell in good faith or by publicly releasing data that they had mere months before insisted was too sensitive to ever make public, defendants have lost their credibility with this court. Wow. Just think if that were you or I that were in that position. What would happen to you or I if we had lost all credibility with a judge in a federal court? Could we be going to jail? Could we be subject to fine, contempt proceedings? We certainly could. What's going to happen to the DEA in this case? Well, time will tell, folks, but I'll tell you, the federal government certainly does seem to be getting a break. They might have to pay some attorney's fees eventually. Let's hope so. Certainly after this, the lawyer for the plaintiff, Mr. Medell, in this case, is certainly going to be asking for attorney's fees, and I hope that the judge will give them. Wow. The judge goes on to say that the DEA has offered nothing more than broad pronouncements and general explanations, and that just legally is not enough. This information is so sensitive, we cannot provide it. Well, why is it that this information is too sensitive? It certainly doesn't seem to be too sensitive because, after all, you are publishing it or very similar information on your own website. Why would you expect this court to believe you when you claim that it's very sensitive when you are releasing it to the public? That certainly doesn't seem to be how people would treat data that is extremely sensitive, yet that's what you're doing. Again, this is how the federal government is behaving in this particular case. And to make it even worse, the DEA is the one asking for the judge to rule in their favor here. It's really mind-boggling. They believe that they have such a strong case that they should just win right now, hands down, no need to go any further. And instead, the judge is saying, not only are you not going to win, but you are losing. You're losing big time, and I don't even believe what you people are saying anymore. And as you go on to read more of this case, if that's something that you're interested in doing, the judge basically says, look, I'm telling you guys to try to work this out among yourselves, but if you can't, I'm going to order the DEA to give this guy the data that he's asking for. So figure it out. Stop playing the games. This case has been going on at least since 2012. Okay. The data that was asked for was from 2006. That's over 11 years. 11 years old, some of this data is potentially. So for you to say that this stuff is top secret, can't possibly release it, even though you already have released it, and to have the data be that old is, the judge seems to be just taking it as a personal insult here, as well he should. So this is the DEA. This is how they behave. This is how they behave in court. Just imagine how they are on the street. Well, we don't have to imagine how they are on the street. We know how they are. This is how they are when they put on their suits and ties and they go into court. We don't have to use a great deal of imagination to know how they are when they're out in their combat gear, carrying their guns, carrying their shields, with their attack dogs and their SWAT teams and the rest of it. So the question is, what are we going to do about it? Well, we have a president that's been in office for really just a handful of days. His mantra seems to be law and order. There's really very little reason to think he's going to step in and do anything about this. The Congress is Republican, and they're very much even against the loosening up of the states' willingness to observe the citizens' demand for marijuana laws that are more consistent with their views. So perhaps the only thing that we can do is continue to work on things from states' rights point of view, and perhaps local law enforcement will refuse to cooperate with some DEA tactics. You know, we have to do what we can. These are people that simply refuse to follow the law. It's quite clear. With this case, there's really no doubt. You really don't need to see anything more to know exactly who you're dealing with when you're dealing with the DEA. Please share your comments. If you think I'm wrong about this, let me know. Tell me why. If you think I'm right, let me know. Tell me why. Appreciate you tuning in. And this has been Chemical Kafka. Have a good day.